Civil society organizations working for peace, justice, and reconciliation in Uganda have welcomed the trial of former Lord's Resistance Army Colonel Thomas Kwoyelo for atrocities he allegedly committed during the over 2-decade LRA insurgency in northern Uganda. Kwoyelo trials officially kicked off on Monday, July 11, 2011 in Gulu, a district most affected by the conflict in northern Uganda. A visibly frightened Kwoyelo was arraigned in a fully packed Gulu High Court session before a full bench, a panel of 3 judges of the International Crimes Division, formerly the War Crimes Division. In March 2009, LRA Colonel Thomas Kwoyelo was captured in the DRC and was flown to Uganda for treatment under detention. The trial day opened with an official opening of the High Court session, a guard of honor and a full parade which attracted a wide range of stakeholders, including victims, local communities, civil society, government representatives, and international participants. Kwoyelo pleaded non-guilty to all the 12 counts and 53 charges read to him one after the other by the Honorable Justice Dan Akik Kiza, head of the ICD.
It is alleged that Kwoyelo Thomas has large on the fourth day of September 1994 at Abera village, Karibanga Parish, Purpose of Lam County, Mikuru District, Northern Uganda, being a colonel of the Lord's Resistance Army, commanded an armed attack against a group of civilians who were not taking any active part in hostilities. We seized, taped, and held hostage to Akena David, Ochen Patrick, alias Olugwai, Odong Menya, John Ouma, Ogong, son of Omoyo, Oko Charles, Oko Patrick, and Ogena Simon, who were protected persons under the 4th Geneva Convention of 12th August 1949.
This trial is as a result of the unrelenting pursuit for comprehensive peace and justice in post-conflict northern Uganda. Civil society actors, local peace activists, cultural and religious leaders have played a big role in demanding for accountability and reconciliation for victims and perpetrators within the region.
We talk about the truth and reconciliation processes in this country, and the Refugee Law Project with a host of other civil society organizations, the Coalition for Reconciliation in Uganda, have so far developed a National Reconciliation Bill proposal, which has been made to the Justice, Law and Order Sector Working Group, as well as other stakeholders, to guide the country in terms of seeking a more comprehensive solution to the conflict. We always believed that the LRA conflict was part and parcel of all the other issues that have been arising in different parts of the country.
The trial, even though just a first step towards comprehensive justice for the entire conflict and its impact, comes as a limestone for the communities and persons affected by the over 2-decade LRA insurgency in northern Uganda. Many of the victims and affected population within northern Uganda expressed a mixed feeling, and some rejoiced the day as a leap in their search for comprehensive justice and sustainable peace and reconciliation, reconstruction and rehabilitation. Many agonized that trial alone will not fulfill their sense of justice, and they called for a more robust measures to be taken to complement the prosecutions of perpetrators.
The International Crimes Division will it make sure that the interests and particularly needs of victims of sexual violence and violence against children are taken into consideration and account at every stage of the court process, because we know that failure to do so will lead to injustice and violation of rights to justice of the victims. We wonder why different standards as under the Geneva Convention and the Rome Statute should be applied in trials for offenses committed within the same jurisdiction. We wonder whether this is fair.
The LRA also continues to attract civilians and displaced populations within neighboring countries like Democratic Republic of Congo and other parts of Central African Republic and Sudan. On the Kwoyelo's trial, many believe that although Kwoyelo is a footnote in the ranks of key perpetrators who bears the greatest responsibility of their suffering, Nonetheless, his trial was considered long overdue since justice delayed is justice denied.
In the judiciary, justice is not a one-way affair. The victims are entitled to justice. The offender or the offenders are entitled to justice. The prosecutors are entitled to justice. And the community, the public, is also entitled to see that justice has been done.
It is the hope of many people that Kwoyelo will be given a fair hearing to demonstrate this country's commitment to due process and the rule of law. Many victims also expect a full implementation of the entire agreement on accountability and reconciliation reached in Juba, including implementation of traditional justice mechanism like matoput, reparations, truth-seeking, and accountability by both state and non-state actors who committed atrocities during the insurgency.
The signal that Kwoyelo's case signifies is very clear onto the roles of traditional justice. Based on accountability and reconciliation on Juba peace talks, Kwoyelo, in terms of traditional justice practices, should have ordinarily been part of the beneficiaries of what traditional justice does. And we should be seeing that his coming out could have meant how can we take him back to integrate within the community. And now it is quite a big challenge because under the accountability and reconciliation, Kwoyelo was supposed to undergo a process of, all this stepping on the eggs, and then because possibly he did something wrong, the matoput process should have taken place, but all these processes have not been fulfilled. And this sends a very wrong signal to the rest of the lower ranking officers of LRA, how possible it is for traditional justice to be implemented. As agreed in Juba, we know that the peace process has stalled, but I think it is quite relevant that this bit of the role of traditional justice should be seen to be playing a central role as far as reintegration in the community is concerned.
Honorable Justice Dan Akik Kiza promised the court's impartiality and commitment to hear all cases brought to court by the prosecutor.
There is a legal notice which was signed by the Honorable Chief Justice. It spells out in clear terms we are going to follow the Uganda law and the procedure and the rules. So the lawyers who are here, if we have been appearing in murder cases, in defilement cases, in robbery, that's the law we are going to use. It's only in certain circumstances the legal notice allows us to follow certain procedures in international tribunals. But that we shall not surprise you. We shall tell you this, and this you have the opportunity to read and see. So there's no ambush, nobody's ambushing anybody.
In any case, Kwoyelo now has the opportunity to prove his case in court and let justice take its course. But in northern Uganda, justice should not only be done, but should equally be seen to be done.
This trial is important. This trial is the beginning of a long road to justice in this country.